Yes, yes. I beg to mention item 3.
2013 matter. Why, Mr. Ali?
Some difficulties on the
Let the
part.
matter reach. Let the matter reach.
All.
Let the matter reach. Item number 3. Wait for some time.
May I please, Your Lordship? Lordship, I beg to mention item 8 of the daily list, Your Lordship. Here the arguing counsel is out of station. We have also circulated the adjournment petition also, Your Lordship.
Lordship, in this matter, education records are called for. The records are available.
So records have come. That's why I fixed it else here. It is stated about that leading counsel for the petitioner Ms. T. Ghosh. Is not available. And in that regard, submitted letter of absence. Please, this one.
Deeply obliged.
Lordship, kindly fix the date. Lordship, kindly fix the date.
Next week.
Next week. Obliged.
Deeply obliged.
My lord, I beg to mention item number 10, 11, and 12, my lord. My lord, dispute, my lord, between daughter-in-law and mother-in-law. And my lord, in earlier 2 occasions, my lord, the matter was sent for mediation and failed. Mediation failed, my lord. In the meantime, mother-in-law side, my lord, has filed a civil suit before Nagaon district, my lord, in the court of Nagaon district. Thus, we have received notice in that case, my lord. May I pray, my lord, 4 weeks time may be granted, my lord.
Let the matter reach. Let the matter.
Obliged.
May I please, Your Lordship? Lordship, prayer for listing WPC 766 2018, Lordship. It is long pending matter, Lordship.
Matter relates to what?
Foreigner tribunal, Lordship. Lordship, I was appointed amicus curiae in this case, Lordship. The matter was last posted on 28/4, Lordship. So it may come up on next week, any date, Lordship.
For 18? Not 8, sorry. For 15th.
15. Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 4 of today's daily list. Lordship, in this matter, we're actually unable to contact the client. So we need some short date so that in the
Let the
meantime.
matter reach. The 21. Let the matter reach.
Obliged.
May I please, sir? I beg to mention item number
Yes.
5, my lord. In this case, my lord, we are filing, my lord, affidavit as per direction of this
Let the
honorable.
matter reach.
Obliged, my lord.
Copy दिया ना कितने? May I please, Your Lordship? It's a contested matter, Your Lordship. Kindly come on page number 28 and exactly, Your Lordship. Into order, Your Lordship. In this case, my brother also deposed, Your Lordship. Thereafter, several documents he had exhibited. But my lord, considering the matter as a miserably failed to research her burden under section 9, X 1947, 46, to prove that she bonded the genuine Indian members, linkage. But my lord, I have annex and exhibited, Your Lordship, Kabin Nawai. On the other hand, Your Lordship, my father's name also appeared in the voter list and grandfather's name also appeared in the voter list of 1966, 1970, 1975, 89, Your Lordship.
Yes, Ms. Verma, this order is of 30th of July 2019. Now that's what we have looked for from the record. It appears from the record that the proceeding remain absent from 2017, but her lawyer was taking step.
Yes, Lordship.
So up to 4th of July 2019,
Yes.
our lawyer appeared, though the procedure was absent
Mhm.
and took time. Then we have seen the Haziras, and up to 4th of July 2019,
Yes.
the 30th of July 2019 was fixed for order.
Final, yes,
And
Lordship.
on that day, the procedure was absent. There was no Hazira filed, and the order was passed.
Yes, Lordship.
So it is only on 9th of May 2023, the
Yes, Lordship.
procedure obtained the certified copy of the order. That too when police visited her house. According to her,
Yes, Lordship.
what do you have to submit? Because 2019, we can understand, 2020 and 2021 is
Lordship,
COVID,
yes,
but this order is of
37, 2019. But all
July
these
2019.
documents, Lordship, all along the proceeding was represented through her counsel. These
Yes.
documents have been submitted by the proceeding, Lordship. So the tribunal has rightly passed the order, even if they had not appeared that day. It was fixed for orders and it was
That's
in
what
their
we're asking
knowledge.
you. This matter is filed after 4 years. What do you have to say?
Lordship will take it up for hearing. We are ready for the
But
hearing.
if it is admitted, then question of considering that point of the submitting the petition in the ground of delay cannot be considered. Once matter is admitted, the question of delay will not come. Till the admission stage, you can consider the delay.
Yes, Lordship.
What is your stand on that regard? Because the petitioner has expressed at paragraph number 25.
Lordship, can this be taken into account that the petitioner had no knowledge? This is just a submission, Lordship. They are very much in knowledge about the passing of the impugned order. We cannot say that the petitioner had no knowledge
That's
about
what
the order.
Before admission or before admitting this writ petition, what is your stand regarding the maintainability of this writ petition on the ground of delay?
As it is, Lordship will know, Lordship will see this proceedings began in 2004. Order passed in 2019, and now if they come up with a stand that we had no knowledge, it does not stand, Lordship. They have the complete knowledge from 2004. They have submitted their documents, procured their documents, submitted their documents, and on the basis of those documents, this order has been passed. There are some judgments also. My friend is telling me, Lordship, we can rely on those also regarding the delay part. And this excuse of not knowing is there in all the petitions, Lordship, most of the petitions, that we were not aware the ex parte order was passed. Even when they contest, they come up with the stand that they plead ignorance, but that cannot be always be the stand, Lordship. Delay को रखते हैं। Since Lordship, on the delay part, we will address Lordship, we're just looking for the judgment. On the other issues, if Lordship wants to hear us, we are ready,
No,
Lordship.
if you want to file a short affidavit, 2 pages of affidavit on the ground of that delay, not because you have not yet admitted this petition. Where the already petitions have been admitted, question of getting the fee of delivery. Okay? So those matters,
Affidavit.
normally you will see, we should notice only in those cases where the question of delay is there. And we write that the point of delay will be considered at the time of its admission.
Hmm.
Here it's clear indication that it is filed after more than 4 years. There was no COVID in the year 2022. So
Yes.
2021, there was COVID. you can consider
1.5 years COVID was looming.
Thereafter, the order was of 30th of July 2019.
19,
There was no COVID till February 22 or March 2021.
20. Yes, Lordship.
So
And not appearing on the date the order is passed, it is deliberate because there is a stand that the day the final order is passed, the
you have earlier
proceeding,
placed a copy of the order that
yes,
remained present on that day.
they have to be present.
But anyway,
Lordship may reject this plea of delay, Lordship, because they are praying for it, and we have a reason saying that COVID started only in March. And their stand that they came to know about it in 23, it is not that they do not reside, they are very much residents of the same place. The address given in the petition and the opinion, Lordship, it's of the same page. They stay in Abhayapuri. The tribunal must be within their reach. They keep meeting people. They know that the matter is
It's
there.
not that they are not aware of them. Once the case is
This,
pending,
taking a plea of this sort, Lordship, it can always be
that's why we have-
rejected.
if you want to place something on writing, it is better for us.
On the question of delay, we have some judgments we can place, that earlier judgments of these bench Lordship. That this is a common plea taken in all the matters, Lordship. 20 years later also they come, they say that we were ignorant, we have no knowledge about the matter. Only when the NRC came up, then we came to know that we had an ex parte case against us. There are so many judgments, Lordship, like this. In my humble submission is Lordships can reject this delay apart and take up the matter for hearing, because not a single document to show the linkage, Lordship. And oral evidence is only of the father, which cannot be relied on.
What do you have to say?
Yes, my lord. The delay grounds already have been stated, my lordship, paragraph number 25, my lordship. My lord, the linkage is also there, Kabinnama is there, your lordship. And my father's name is also recorded in the voter list of 1975 and 89, your lordship, along with my grandfather, your lordship.
Where is your written statement?
Yes, my lord.
Okay, let us read your written statement.
Written is, page number 16, your lordship, annex 1. Next is respectfully the humble opposite party begs to state that your lordship, that the above case is not maintainable both in law and facts, hence liable to be dismissed. That the allegations of Union of India through SP border is totally false and baseless, hence liable to be dismissed. That the opposite party denied the allegations of Union of India and also denied the inquiry report, if any. As these allegations and inquiry report are false and fabricated, that there is no cause of action in the above case, hence liable to be dismissed. That the inquiry officer not properly inquires the case and not given any opportunity to submit documents in her support. That the opposite party also deprived from getting justice, as no copy of ground of allegations has been provided and applied with the notice of this case. Hence, the case is not maintainable. That the opposite party is not a foreigner or Bangladeshi, nor have any domicile in Bangladesh. It is also not a fact that the opposite party have entered into the territory of India illegally without any valid documents after 25th March 1971. That the opposite party reserves the right to file additional written statement, additional evidence and documents if required with the leave of the Honorable Tribunal. That the opposite party is a bona fide Indian citizen, as such entitled to the right and privilege of constitutions of India and other laws framed thereunder. Hence, the opposite party entitled to the benefit of section 3 clause 1 clause A and 3 clause 1 clause B of Indian Citizenship Act 1955. That the opposite party is a bona fide Indian citizen by birth. Opposite party born at village Hapasara, PS Bagbor, district Borpeta, earlier Kamrup, Assam, India, about 35 years ago, which was the permanent domicile of the parents of the opposite party. That the good and correct name of opposite party is Rahila Begum, but she is known as Rahila Khatun and Rahila Khatun in the society, which are her nickname. That Rahila Begum and Rahila Khatun and Rahila Khatun is the same and one person. That this case, the nickname of the opposite party, Rahila Khatun, has been mentioned. That the name of the great grandfather of the opposite party is Sikat, Ilyas Sikat Ali, and grandfather's name is Tomesuddin, Ilyas Tomes, and grandmother's name is Zorina Khatun. The grandfather of the opposite party has died. The grandmother of opposite party is still alive. That the name of the father of the opposite party is Sirazul Haq, Ilyas Sirasuddin, and mother's name is Rabia Khatun. Both the father and mother of the opposite party is still alive. Both grandparents of the opposite party are bona fide citizens of India. That the grandfather of the opposite party, Tomisuddin, have one son, that means Sirazul Haq, Ilyas Sirasuddin. The father of the opposite party, the grandfather of the opposite party had no daughter. The father and mother of the opposite party are bona fide citizens of India. That the father of the opposite party have four sons: Rahim Ali, Rafiqul Islam, Ahmed Ali, and Nuruddin, and six daughters: Siatonnesa, Fulmoti Begum, Rohila Begum, Rahela Begum, Ilyas Rahela Khatun, the opposite party, Nazma Khatun, Almina Khatun, Mormi Khatun. All the other sons and daughters of the father of the opposite party are bona fide citizens of India. That the name of the maternal grandmother's fathers of the opposite party is Abu Alam, and grandmother's name is Joyful Nesa Ilyas Joyful Begum. They are bona fide citizens of India. Maternal grandfather of the opposite party have two sons, Joinuddin and Mainuddin. They are living now at village Dumuria, PS Obhayapuri, district Bongaigaon, Assam, and have three daughters: Rabia Khatun, the mother of the opposite party, Sundari Begum, and Firuza Khatun. They are alive. That the paternal grandparents alive at village Hapasara, PS Bagbor, Elder district Kamrup, Assam, and during staying at village Hapasara, their name entered in the voter list of 1966 of 52 number Bagbor LSC, White House number so, serial number so. Another A is the voter list of 1966 LSC. Page number 19. Annexure number B is the voter legacy data of 1966. That the name of the grandfather, mother of the opposite party also entered in the voter list of 1970 of village and LSC, White House number so, serial number so, and so, is the great grandmother of the opposite party. Annexure number C, 1970 voter list. Paragraph number 19. That the father of the opposite party, Sirazul Haq Ilyas Sirasuddin, cast his vote along with father and mother, grandparents of the opposite party at village Hapasar in the year of 1985. But the election officer of Borpeta district suspended the process issuing of something is handwriting, your lordship, I have not got. Opposite party could not submit the voter list of 1985. Paragraph number 20. That the name of the father of the opposite party also entered in the voter list of 1997 at village Hapasar, along with mother Joina Khatun, grandmother of the opposite party, and the opposite party, though applied for certified copy of the voter list, still not able to collect the same, for which the opposite party reserved the right to submit the said voter list of 1997 at the time of hearing. Evidence with leave of Honorable Tribunal. 21. That due to effect of flood and erosion, the parents family of opposite party shifted from village Hapasar, Kamrup, now Borpeta, to village Amguri Part 1, PS Obhayapuri, district Bongaigaon, Assam, in the year 1998, and started to live there permanently. As such, now permanent domicile of parent of the opposite party is village Amguri Part 1, and during living in this village, the name of father of the opposite party entered in the voter list of 2005, 2008, and 2010, and in the voter list of 2011 and 2015, along with mother, grandmother of the opposite party, Zoina Khatun, along with wife, son, daughter-in-law. There are still some land in place, Hapasor, in the name of the father of the opposite party. Annexure D is the voter list of 2005. Annexure D 2018 voter list. F is the 2010 voter list. G is the 2011 voter list. S is the 2015 voter list. I is the 2011 voter list of the mother and grandmother of the opposite party. Annexure J is the voter list of 2015 of the mother and grandmother of the opposite party. Paragraph number 22. That the good name of the father of the opposite party is Sirazul Haq, but he also known as Sirajuddin in the society, which is his nickname. That Sirazul Haq and Sirajuddin is the same and one person. That as earlier resident place Hapasar PS Kolgasia now, District Borpeta Assam, the government Gaubhora of village Hapasar has issued a linkage certificate in the name of the opposite party on 7/12/2016. That's serial number answer. Annexure K is the government Gaubhora certificate. Paragraph 24. That the present resident village of father of the opposite party is village Domoria, which falls under Kalbari GP, and Kalbari GP has issued a residential certificate in the name of the opposite party. Gapanse certificate, you understand. L is the Gapanse certificate. 25. That the father of the opposite party possessed a plot of land as permanent settle holder jointly with mother-in-law Joyful Nessa Ilyas Begum and brother-in-law at village Amguri Part 1 under Trijon Gram Revenue Circle, height PK Patta number 119. In this PK Patta, the name of the father of the opposite party has been written as Sirajuddin, and also got Jamabandi of land, also paying revenue to the government. Annexure M is the Kesapatta. Annexure N is the Jamabandi. Annexure O is the revenue received of this said land paid by the brother-in-law of the father of the opposite party, that means by Mainuddin. Annexure P is the revenue receivable. 26 paragraph. That the opposite party got married with Umar Ali, son of late Umed Ali of village Dumoria Part 2, PS Obhaipuri, District Bongaigaon, Assam on 28/1/21 with registered Kavinnama, and at the time of marriage of the opposite party was 18 years old. In the said Kavinnama, the father of the opposite party signed as guardian father of the opposite party. Annexure Q is the marriage Kavinnama. 27. That as the opposite party, daughter of the father Sirazul Haq and resident of village Amguri Part 1, as the opposite party got married with Omar Ali, the Kalbari Gapanchayat GP has issued a linkage certificate in the name of the opposite party, file serial number sensor dated 15/11/2016. Annexure R is the GP linkage certificate. 28 paragraph. That after marriage of the opposite party, husband Omar Ali, and during performing conjugal life with the husband and village Dumoria Part 2, the name of the opposite party along with husband and other family member entered in the voter list of 2010, heights house number census, serial number census. In the voter list of 2016, height house number census, serial number census, Ohepuri SC LSC. Annexure S is the voter list of 2010. T is the voter list of 2016 units. 29 paragraph. That the opposite party bona fide citizen of India has got voter ID card from Election Commission of India, via voter ID number sensor. In this voter ID, the name of the husband of the opposite party written as Omar Ali. paragraph 30, that the maternal grandparents of the opposite party are bona fide citizen of India, earlier live at village Hapasar, PS Bagbor, district Kamrup, Assam, India, but subsequently shifted to village Dumoria, PS Abhaipuri, district Bongaigaon, Assam, and during staying at village Hapasar, the name of maternal grandfather and mother entered in the voter list of 1966 of 52 number Bagbor LSC. Annexure U is the voter list of maternal grandparents. Annexure V is the Calvary GP linkage certificate of the mother of the opposite party. 31 paragraph, that actual age of opposite party is 35 years now, but in the voter list and voter ID, the age are entered as less and more. Paragraph 32, that the opposite party is not a foreigner or Bangladeshi citizen, nor entered in India after 24th March 1971. Opposite party have not any address and domicile in any place of Bangladesh, nor have any relative. The opposite party is a bona fide Indian citizen by birth, being child of same parent of other brother and sister who are bona fide Indian citizen. 33, that under the premises of annexed documents, the opposite party above to prove that she is bona fide Indian citizen and prayed before the Honorable Tribunal to discharge the opposite party from this case. Therefore, Your Honor, for the end of justice, would be pleased to dismiss the case by declaring the opposite party as a bona fide Indian citizen. This is the rule. And my father's deposition is page number 25, Your Lordship. Annexure 2.
Ms. Verma, have you gone through the records?
Check documents because the voters list 50 and the next petition was never exhibited before the tribunal.
Please take your. Which is your link document?
Kabinnama is the link document. Your Lordship.
Hmm?
Kabinnama, page number 53, Your Lordship, Annex 13.
Kabilnama,
Yes, my lord.
proved by whom?
My lord,
Proved by whom?
what?
Whether Kazi adduced any evidence?
No, my lord. They did not any evidence, but my lord. But my lord, it is exhibited, Your Lordship. Exhibit S, Your Lordship.
Yes. Yes, please come to page number 19 of your writ petition.
Yes, ma'am.
Read para 19, 20, 21.
That the father of the opposite party, Sirazul Haq, alias Sirajuddin, cast his vote along with father and mother, grandparents, the opposite party at village Hapasara in the year of 1985. But the election officer of Borpeta district suspended the process issuance of certified copy of the voter list of so party.
So
Yes, madam.
Prositi's father,
Yes.
PW2, for the first time cast his vote in the year 1985, right?
Yes, yes, madam. Chapter paragraph 20,
Hmm.
that the name of the father of the opposite party also entered in the voter list of 1997 at village Hapasar, along with mother Joina Khatun, grandmother of opposite party. And the opposite party, though applied for certified copy of the said voter list, is still not able to collect the same, for which the opposite party reserved the right to submit the said voter list of 1997 at the time of hearing evidence with the leave of honorable tribunal.
Hmm.
21. That due to the effect of flood and erosion, the parents family of opposite party shifted from village Hapasar, Kamrup, now Borpara district, to village Amguri, part 1. Yes, Abhaipuri district, Bongaigaon, Assam, India, in the year 1998 and started to live there permanently. SS now permanent domicile of parent of opposite party is village Amguri part 1 and during living in this village the name of father of opposite party entered in the voter list of 2005, 2008 and 2010 and in the voter list of 2011 and 15 along with mother, grandmother of the opposite party, Joina Khatun along with wife, son, daughter-in-law. There are still some land in
Okay.
village Hapasar
Okay,
in the
Please
name
wait,
of.
please wait.
Yes, ma'am.
So here you have stated, the procedure stated that in the year 1998
Shifted here.
shifted to part 1 Amguri village under Abhayapuri police station of district Bongaigaon.
Yes, ma'am.
And now permanent domicile of
Amguri.
her parent is at Amguri part 1,
Yes,
right?
ma'am. Yes, ma'am.
And shifted in the year 1998
Hmm.
and entered in the voter list of 2005. After, please take it. Started residing at Amguri, Bongaigaon, Abhayapuri, Bongaigaon. Okay. Now please come to para number 26.
Yes, my lord.
Is number 21.
Yes, my lord. That the opposite party got married with Umar Ali, son of late Umed Ali, of village Dumuria part 2, PS Abhaipuri district, Bongaigaon, Assam, on Iman, with registered Kabinama. My lordship.
Hmm.
And at the time of marriage, the opposite party was 18 years. In the said Kabinama, the father of the opposite party signed as guardian father of the opposite party. Your lordship.
Read next para.
That as opposite party daughter of father of Sirazul Haq and Sirazul Haq and resident of village Amguri part 1 and as the opposite party got married with Omar Ali, the Kalbari GP has issued a link certificate in the name of the opposite party flight serial number so dated so.
This Kabilnama that you have annexed
Yes, my lord.
was proved by the Kaji.
No, my lord. It was not proved, but it is exhibited here.
Now, '75 voter list, 1989 voter lists were not exhibited, right?
Yes, my lord, but we have
They're
annexed.
not exhibited.
But and on that time, my lord, we could not collect the certified copy, my lord.
Whether 1966 voter list that you have annexed at 33 is a certified copy.
Yes, my lord.
How do you see it?
The 1966 voter list and 1970 voter list, my lord, my grandfather's name.
We are asking whether 1966 voter list is a certified copy.
Yes, my lord. 1966 is
Wherefore you are saying that
32, my lord, page number.
Hmm?
Page number 32.
32,
Yes, my lord.
Hmm.
Annex 4, my lord.
right? Very good. Then what is the difference between page number 32 and 33?
But, one is type copy and another is vernacular copy.
What is the difference between what you have seen from page number 32 and 33? What you have seen? It is apparent there.
Relevant portion, Your Lordship.
You have not seen anything?
My lord.
Do you have the Evidence Act with you?
No, my lord.
No.
Today,
Read section 76 of the Evidence Act. Read section 76.
76. Certified copy of public documents, Your Lordship. Every public officer having the custody of a public documents which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees. Therefore, that person on demand a copy of it on payment of the legal fees. Therefore, together with a certificate written at the foot of such copy that it is a true copy of such documents or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal. And such copies so certified shall be called certified copies.
Now, come to page number 32,
Yes, my lord.
or if you compare with the vernacular at page 33, do you find such seal as required under section 76 of the Evidence Act?
Yes, my lord, but my lord, there is no seal, but there is
Good.
signature also. LR thus.
Signature is not enough. What is required under section 76?
Yes, my lord.
That is available
Yes.
at page number 35,
Certificate.
down below. Page number 35 is the voter list of 70. Have you noticed? Page number 70,
Yes, my lord.
what is there?
But
Or page number 34? You have written there. What is written there?
Certified to be true.
What is written there?
এই সত্য প্রমাণিত নকল Your Lordship,
Is
নির্বাচনী
it
বিষয়ে
written there at page number 33?
35 is the
Page number 33, is it written there?
33 is not written.
Not written. So it will not come under the Evidence Act. So it is not a document to be considered for the purpose of evidence, right?
Yes, my lord.
So this goes. Now next, please come to,
But my lord, this certificate could be provides
Maybe.
us from the election officer.
I
Your
do
Lordship.
not know, to consider as a
Yes,
piece
my
of
lord.
evidence,
We have to.
if it is a
Consider.
certified copy of a public document, this thing has to be there, it's prescribed in the act, and we cannot go beyond the act. Can we go?
No, no.
Now please come to page number 26.
26. Yes, my lord. Deposition of my father. Your Lord.
Hmm. Have you annexed the evidence of your father, affidavit in evidence?
No, my lord.
You
It's
have
a-
not.
I think it's a cross
You have only enclosed the
oral
cross.
evidence. Cross and oral evidence.
Ms. Verma, you can read assembly? Okay, no problem. You can read. Sharma, you can read. Mr. Ali, you can read. Mr. Sharma, kindly read para 9. That's in the affidavit in evidence of the DW2. It's not the cross. Para 9. Please come to the desk. Kindly read.
মই কওঁ যে মই আমগুৰি গাঁৱত মোৰ দুই সন্তান আহমদ আলী আৰু নুৰুদ্দিনৰ সৈতে মই পৃথকে থাকো আৰু মোৰ শ্ৰী আন সন্তানৰ সৈতে বেলেগে থাকে।
So there the father of the proceedee have clearly stated that after coming to Amuguri,
Yes,
he along with his two sons are staying separately,
separate.
and his other children along with his wife live separately, right?
Yes.
You have heard, or you want to see what he has stated in para 9? Yes, Mr. Counsel. So
It is all. It is.
paragraph 9. You can read Assamese?
পিছত মোৰ দুই সন্তান
জোৰকে পঢ়া।
You can read Assamese?
Yes, my lord.
You read it for yourself.
মই কওঁ যে মই আমগুৰি গাঁৱত অহাৰ পিছত মোৰ দুই সন্তান আহমদ আলী আৰু নুৰুদ্দিনৰ সৈতে মই পৃথক থাকো আৰু মোৰ স্ত্ৰী আন সন্তানৰ সৈতে বেলেগে থাকে।
Good. Give it to us. So you are living separately. You are not living with your father or parents. You are living with your mother. Come to page number 54. Your Kabil Nama. What is your address? Serial number 2 in the vernacular.
দুলহিন বা কইনাৰ নাম ৰহিলা বেগম, বয়স 18, বৰ্তমান ঠিকনা 1 নম্বৰ আমগুৰি।
How come? How come Ek number Amuguri? Only your father used to live with your mother separately, not with your father. That you have seen in the evidence.
But at the time of marriage, my lord, my
You do not know. After coming to Amuguri,
yes, my lord.
your father along with your two brothers, alleged brothers, we're not saying protected two brothers and protected father, live separately
Yes, my lord.
at Amuguri. There is no mention that you along with your mother stayed in, but it is the fact that you live separately. That's there in the evidence you have read just now. How come your address is number 1 Amaguri?
But my lord, at the time of
You
marriage,
do not know.
I was
It is you saying, but your father is saying you are living
yes, my
separately.
lord, I was living with my father. It may be my
You are
lord.
not living with your father.
Mother.
Mother.
So
It's my
where
lord.
is the address?
At Amuguri, my lord.
Where from you are saying? Yes, now tell us,
Yes, my lord.
how you have proved.
My lord, I married on my lord
That is
28
there,
1
you might have married.
2001, your lordship.
You might have married.
Yes, my lord.
What is your address?
Yes, my lord. In 2021, my lord, yeah, I was Amguri Part 1, your
How
lordship.
can you say that? How?
Oh, my
You
lord,
have any school certificate to show that?
but there are some linkage certificate, your lordship, Panchayat certificate and
Panchayat
Gabra
certificate.
certificate is also there, your lordship. But I have not
Panchayat
enacted,
certificate
your lordship.
issued by whom? Your father have clearly stated that I, along with these two sons, living separately. And my other children, along with their mother, with my wife, living separately.
They separately maybe living, my lord, but at the same place,
We
your
are not
lordship.
here on may or but. It has to be specific.
Yes, my lord.
By which document you will show that you are a resident of Amuguri Part 1?
I have not annexed the Gabra certificate and Panchayat certificate, my lord. On record,
Have you annexing documents being the writ petition will not do? Have you exhibited it before the tribunal or not?
exhibited, your lordship.
Which document you have exhibited?
Yes, my lord. Exhibit Q is the link certificate.
Exhibit Q is your Kabilnama.
No, my lord. Yes, is the Kabin Nama. Q is link certificate.
Exhibit Q,
Yes, my lord.
just.
Q and R.
Q and R.
Yes. There is no mention in Exhibit Q that you are the daughter of Sirajul Haq,
My lord, R. R is also a link certificate.
issued by whom?
Gaon Panchayat certificate, your
What
lordship.
is it? Read it.
In the name of Sirazul and
Where
Rohila.
is there? Kalbari Gaon Panchayat have issued a certificate.
Yes, my lord. Kalbari Gaon
That
Panchayat.
procedure is the wife of
Wife of Omar Ali.
Rabia Khatun, daughter of Abu Alam. That is your mother probably, protected mother
Mother.
or father, I don't know, that is at Duramari.
Hmm.
So you are a resident of Duramari. Rabia Khatun is your protected mother. So she stayed at Duramari. This is clear.
Yes, my lord.
You are not at Amoguri.
Yes, my lord. There are another two certificate, my lord. Exhibit W and X, your lordship. Gaon Panchayat certificate. Can't know this is W and X.
Sirajul Haq doesn't stay at Kalabari. And he has no right to give a certificate of Amoguri Part 1. It is not under his charge.
Panchayat name may be different.
Panchayat certificate doesn't come, Amoguri doesn't come under that Panchayat. That is the reason. Have you examined the concerned president or the secretary who issued this certificate? You did not. It has to be proved.
Exhibit W and X. Your lordship.
So W goes. Now what about X? Given by whom?
It is also Gaon Panchayat certificate. But
Who gave you? Exhibit X relates to what? It was issued by the Gaubura.
very Gaon Panchayat.
When it was issued? On which date? Whether this Gaubura has been examined? Whether he adduced evidence?
No, my lord.
No.
No
Now-
prosecution witness examined.
Page 30, your lordship. The impugn order itself reflect, your lordship.
You have the exhibits are before us.
Yes, ma'am.
Whatever is in the order, we are not at this
Yes,
stage.
Exhibited, your
Have
lordship.
you
but
proved?
Not proved, your lordship.
Now, here it is a particular Gaubura who has given this certificate. From what? From what? When this Gaubura took charge? When he assumed the duty as a Gaubura? He has issued this certificate on 7th of December 2016, during when the
NRC
proceeding
was in,
was.
with the
Exactly.
NRC was also in process.
And
Lordship.
secondly, please come, he has stated that you have shifted to Amaguri, wherefrom he knows. He can say he was a resident of such and such up to this period,
Yes, my lord.
but wherefrom he can say that he has shifted to Amaguri.
Voter list.
It will be his personal knowledge, but he has to see it on from record. Now, please come another thing. Please tell us. Page number 35, you can read vernacular or you can read also page 34. That's in English, translated copy.
My lord,
What is the name of the village? What is the name of the village?
Hapasar, your lordship,
Apat.
35.
Next page is 36.
Yes, my lord.
That is the real name. Hapachara.
Hapasar, your lordship.
It's not Hapachar, but it is Hapachara.
Hmm.
Now, that voter list is of 1975.
Yes, my lord.
Let us assume that is Siraj Ali is your projected father.
Yes, my lord.
Let us say. Come to page number 38. What is the name of the village?
Hapasar, Pathar, non-K.
Non-K.
That's totally different village. Non-K means non-cadastral. It is not under the revenue record.
But my lord,
But the village is Hapachara in the years 1975.
Moza district LSC is the same.
Whatever may be, that is not to be considered. A village
Yes, my
has to be a revenue village. The next time which is a voter list that you have shown here
lord. Non-K.
is a Hapachara Pather
Non-K.
non-K. That means it's a non-cadastral area. It's a pothar,
Hmm.
right?
Yeah.
So it is Hapachar, not Hapachara. Because these are documents of the Election Commission.
Hmm.
You cannot twist and turn.
$70.89 were not exhibited also
It
before.
was not
the
actually,
tribunal.
even for
Yes.
assuming that
Yes,
in
Lordship.
itself, because these are certified copies, we are assuming that it is considered. Even then, and you have seen from the document that you stayed with your mother in a different village, not at Amuguri one. Your own document which you have exhibited. Only to bring that link with Sirajul Haq.
Sirajul Haq.
Yes,
That is the evidence of your father.
Hmm.
And you lived at Dimaguri, I think so. That will be a cartoon. Yes. So how will you establish your case? You lived with your mother at Duramari. Because that is the statement of your father. Lived separately. And your mother is a resident of Duramari. Tell us anything else?
My lord, my father has been deposed, your lordship.
Your father has deposed.
Yes, Abhinav is also there, your lordship, and
You have to,
my mother separated, my lord.
there is nowhere you have stated. It is not there in your written statement,
No, my lord.
only
Yes,
in your father.
say it, your lordship. Deposition time. My lord, I have a limited your lordship. Give me one more chance to prove my
The
case.
thinking of chance doesn't arise here.
Yes,
That you should have placed it before the tribunal,
yes, ma'am.
not here. By filing a writ petition challenging that order.
Yes, ma'am.
We are here in a certiorari. What is our role to play in a certiorari? Only to see and verify whether the order passed by the tribunal is bad in law or in good in law.
Yes, ma'am.
We cannot go beyond that. Can we? Show us any judgment by which the Honorable Apex Court has said while exercising the power under certiorari, the writ court can do this and that. Only thing is to find out whether the order passed by the tribunal. We can read the judgment of C. Chandra Kumar, the full bench judgment of the Apex Court. The writ petitions filed against the order passed by the tribunals, central administrative tribunals, right? Thereafter, it was amended. Why?
My
You
other,
read the judgment, you'll be knowing fully well what is the role of the writ court while exercising the power under certiorari. We have seen many such orders.
yes, madam.
It is correct. But can we go? That's why we're asking everyone. All the councils either appearing for the proceeding or against the proceeding to tell us whether can we go to that extent while exercising the power under certiorari. We can straight away reject. Or if we find that there is an illegality in that order,
Yes, madam.
can we direct?
Then madam, I have to take some time, my lord,
The-
for,
Which, after hearing too much recognition of.
Yes,
things,
my
too
lord.
much time doesn't arise.
yes, my lord, but
Should
my
have
lord,
prayed in the morning itself.
my lord, Kavinama is also there, my father. also
Kabil Nama
there.
may be there, eh?
It may be, yes, my lord, I will prove your lordship next
Now
time.
which
So
is
give me
the
one more
right-
chance to, from the evidence is there, your lordship.
You have not stated that you live separately
No
away
way,
from your
Lordship.
father along with your mother. It is your father who have clarified. Now we have seen, how come the Kamil Nama can be accepted? You should have said you are the resident of that Dumuria, Dimaguguri, whatever.
But my lord,
You are living
my
with your
father
mother.
said, he has been living separate from my mother also, but the year is not, time is not there also. From where, but
That is.
In
what
this regard, I
you
could not
should
say.
place it.
Yes.
But you have said in your affidavit in evidence.
Yes,
You
madam.
have not stated in the written statement, but you have stated in your affidavit in evidence.
Yes, madam.
Why?
But my
So you
lord,
know the outcome.
yes, my lord, in the affidavit also, he also said also, my lord, opposite party is my daughter, your lordship. Then it is maybe consider your
Do
lord.
not know. That is the reason why you should have examined the Kaji.
Yes, my lord.
Lordship, apart from the father's oral evidence, nothing else is on record to show, and no prosecution witness was examined. The voters lists are also not in consonance, or they do not have the linkage with the proceeding, Lordship. And regarding oral evidence, Lordship, I would like to state that under the Act also, Foreigners Tribunal 64, the evidentiary value of oral testimony without support of documentary evidence is only insignificant.
That's what, there are judgments with regard to
Yes,
that.
many judgments, Lordship. Oral testimony alone is no proof to citizenship. And father himself has stated that his name appeared for the first time in 1985, but that has not been exhibited anywhere. And the tribunal has taken note, even the proceedee has said that only after 2005, the father has voted continuously, Lordship. And as many as 29 documents have been exhibited before the tribunal. None of the documents have been proved, Lordship. And even the voters list, there's some shifting has been there, which he has explained in his,
Apart also, I'm good.
huh?
Only one.
the one shifting is that has been explained, Lordship. And as Lordship has seen that the certiorari jurisdiction will not, this court would not, is being supervisory, and Lordship has said not appellate, Lordship would not like to go into.
No, no, if you
Lordship.
have some judgments, give it to us, we'll consider.
Yes, Lordship, we have Regarding the certified copies also, we would like to place. Certiorari, certiorari, we can rely on Muslim Mandal Lordship, para 112.
That was again relied on the basis of a judgment of the apex court.
Yes, Lordship, and that is Santlal Gupta. 2010 13 SCC 336, paragraph 28, Lordship.
Page number,
Paragraph 28, on page
That's right,
number
it was-
336. 2010 13 SCC.
336.
Yes, Lordship. Para 28, Lordship.
Yes.
And section 76 of the Evidence Act, which Lordship has also pointed out, we would like to rely on that. And oral evidence in WPC 562 of 2016, Lordship.
It is reported in.
It is also reported, Lordship.
WPC 562 2016,
Yes, Lordship.
reported where?
2018 GLT 118.
2008, it is reported in 2018, 3 GLT 118, Lordship, Bijoy Das. Paragraph 17, Lordship. Oral evidence. Oral evidence of the father, Lordship, would take into consideration WPC 4020.
Just a minute, let us see first one. Let us see the JLT. Please take your seat. নাপাকে কি হয়? ক'ব লাগে ন আপলোড কৰা বুলি ক'লে এইটো মানে কাটি যায় এটা বস্তু মাৰি থাকিব লাগে।
Which I read, 2018 something.
This issue that reported in 2018 3GLT 118. There is an old judgment, it will find it only in AIR. That is also relates with Foreigners Act. A person who was in Pakistan, undivided Pakistan, came to India, undivided India. Later, after partition, he shifted to Pakistan. Then he again came back to India. In that particular matter, he was considered as a foreigner because after partition, he went back to Pakistan and then again back to India after partition. And there they, I forgot its name, or something, it was the case. It is only available only in AIR, so or in the SCR. There it was considered, there the evidentiary value. Just mayor saying will not do because he came without any document. He came to India because he was not a successful businessman there at Pakistan. You had a successful business at India, no doubt. But since he came without any valid document, he was considered to be foreigner. So mayor saying will not do. It has to be had an evidentiary value. That was where it was considered. Go through that judgment. It's an old case, maybe around 72 or something like that. I don't know. What is the party's name? Manwaru Khan. But it's a old case, quite old case. It's only in AIR. I didn't read in SCC. I have seen it only in AIR. Because
This is the case, Lordship is referred to. The accurate case of proof by evidence whatsoever they had not violated an
probably Probably. Forgot the party's name. Yes, what is the citation? 2002 4 SCC.
2002 4 SCC 346. If long stay in the country and enrollment in voters list did not confer citizenship.
That's where the judgments you have seen in the revision bench earlier. On the basis of that.
It was also respected in quite a number of cases. And in continuous stay. Logical, the documents which are voters next year, 66, 70, and then direct 2005. There's no continuity of the voters list, but here it has a next. So it's not exhibited in the.
Not exhibited before the tribunal, but those are exhibit, they have obtained the certified copy, but the villages are different. Villages are different.
Yes, sir.
That has to be considered.
And the no voters list has the father's name with the son. Or the grandfather's name with the father and father in the. son.
Projected further, that is only the one, but the village things are different. That's the
Yes.
reason we have.
And Lordship, the other voters list of the proceed, divided box, single name voter list, not with the son. Even up to 2011, it does not contain any other family members' name. It runs which are exhibited in the special also. Lordship. The last few pages I just saw page 51, page 52. Without single name voters list. Rajul has 49 his son's name or ought to have been there, his wife's name ought to have been there. Page 51, 52. The recent voters list also has the family members' name.
See, evidence cross of father of the petitioner.
Page 25. The initial states that my name appeared for the.
Now
first
here,
time in
the
85.
date of birth of the father, the DW2, the projected father, as per this 12th of October 1958,
Yes,
right?
yes, sir.
Now please come to page number 36. You have to check up whether it is a voter list, genuine voter list or not.
75 voter list.
Now, let us assume this Siraj Ali is the projected father of the petition. If his date of birth is 1958, whether his name can be entered in the voter list of 1970. Remember, at that point of it is 21.
21. So whether the Siraj Ali before
Absolutely
this
not.
And this document
Cannot
are
be.
one and the same person.
That itself
That
goes.
also is a question mark.
That itself goes. That's the reason we are asking, because he cannot be a 21 years old
Yes.
in the year 1975.
This is a certified copy and this is his own statement. So we'll go by the own statement of the certified copy.
That only Mr. Ali can look into it, whether this is genuine or not. But anyway, he clearly stated that his date of birth is of 1958, as per the school certificate. He cannot have been a voter in the year 1975.
And this.
এই দিন নিদিও 2 ঘন্টা হলো
is
আর
here,
10টা
never
15 পরে
exhibited.
Not
So that means it has been got later on.
কোন
not just-
কনসিডার করিব
Even if it was-
কনসিডার
It has been arranged later.
it's been more time.
now there is a statement somewhere.
So people you can notice the page 37, Siraj Ali, son of list and this voters list, the people, only one name is similar, other names are all mismatched. plots.
Name is similar, title is different.
Then again, lordship will see Siraj Ali become Sirajul Haq.
That's right.
89 voters list, he becomes Sirajul Haq. And Pervez is there, he's 39 years. Rabia Khatun, his wife's name is there. Atul Sukun, I do not know, I've not seen this name in any of the voters. A new name comes up. Lordship. Nine voters list and 75 voters list, if they are the same people. also. Ninety-seven, Sirajul Haq and Rabia Khatun is there, which subsequently losses Sirajul Haq becomes a bachelor again, and his name is Sirajul Haq with summative age. The correction happens only after 2005, 2008 and 2015. Where the father's name appears correctly.
It is the case of the procedure that for the first time, the father of the petitioner asked in his vote in
2005,
1985.
yes.
Voter list could not be placed. The question of 75 voter list will not come. Would not have been exhibited because it is the case that it is for the first time cast a vote on in the year 1985.
55.
Same thing also been reiterated by the EW2, the projected father of the petitioner.
Yes. He has also stated that her father's name was recorded in the voters list for the first time in 2005 in Abhaya Prison,
Exactly.
and stated that her father's name in the voters list 2008, 10, 11, 15.
DW2 in his affidavit in evidence stated that his name figured along with his parents in the year 1985 and 1997.
Those two were not exhibited law.
Rightly, and in his all cross,
Yes.
he said that in the year 1985, he cast vote for the first time.
First time.
So
That means
Mr. Ali,
no,
whether these voter list, we do not know. It should be understood. Anything had happened during NRC.
nothing to show.
But
that
anyway, we have a
she is
register
not
now, whether rightly, wrongly, some base is there. Which is the other order you have to say that regarding documents, oral evidence will not do? Some order of the court you said,
That was, relied on 2018 lordship.
then another decision, you said.
GLP and the tertiary one was Sanjay Gupta
That's right, 2008,
and father
2002, 4 SCC 346, right?
regarding his teacher bringing in new documents here. Which is actually, 2021 1 GLP 799.
2021,
2021 1 GLP 799.
790,
799.
799. 2021, 1 GLT 799.
Yes, paragraph 14. rely on paragraph 14, 17. The document. That document is relied on. Is backed by the mutation of
There is no mutation now. There is no order of the circle
the
officer.
circle officer. Yeah.
Both the issues, whether it is the cell deed at district Borpeta or cell deed in the district of Bongaigaon.
The CAD produced of 1985, nothing. So, um, the father's oral evidence not just. You could try to rely.
4020-2017. 4020, right?
4020-2017.
Decided on
Father decided on 21/11/2019.
just a minute.
Statement of DW2, Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in the absence
Decided on
of
21st of
21st of November 2019.
okay.
Here we would like to rely on the paragraph numbers are not there, Lordship.
Anyway, which
Yes,
page?
even it even covers the land document. Jamabandi not supported by the mutation order. The Jamabandi documents has no relevance as it does not serve the link to the petitioner with the projected father. And the second paragraph is the statement of DW2, Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in the absence of any documents showing his relationship to the petitioner, Lordship. And again, we can even rely on this one for oral evidence, Lordship. And regarding fresh documents also, the petitioner have enclosed few documents with the writ petition for consideration. We would observe that fresh documents introduced in the present writ proceedings cannot be looked into or considered, the same not having been produced, exhibited and proved before the tribunal at the first instance. So this covers almost all my points in this matter, Lordship.
Anything else? If you want to give anything, any judgment, you give it to us by tomorrow,
Yes, sir.
okay? In support of your petition. But we've asked the ingredient. We have noted down, but even then you give it to us
But
if you have something.
voter list of 1966, your lordship, there is a certificate to be true to your lordship.
But how, where is
This
the
is
link?
originally one.
Where is the link to show that
Leaving to that was point out.
that's the father and mother of the DW2? Because you have said you have for the first time you have voted in 1985. And in 1985, your voter list.
And 1975, his
there.
age comes to 25, whereas it couldn't have been.
He couldn't have till 79, he could not have voted. School certificate is very clear. Born on
Yes,
the year
correct.
1958.
Date of birth is there.
And stated by the DW2 himself, Lordship.
You are Mr. Rahman,
I'm a Islami lordship.
not Mr. S. Islam, and counsel for the petition. We'll pass the order in today's date,
Yes, ma'am.
but if you have something to give it to us.
Okay.
Who is appearing? Who is the CGC? Here. You will appear?
Lordship, regarding the delay part, I would like to refer to one more order, Lordship. That is in case number WPC 7099 of 2019.
WPC 7099.
Yes, Lordship of 2019. Decided on 24/1/2020. Paragraph 5, Lordship. May I read it?
Please.
We have gone through the judgment of the learned tribunal. The judgment was passed on 1/6/2005, and this writ petition has been filed in the year 2019.
This was authored by whom?
Lordship, Justice Manojit Pui and Parthiv Jyoti Sekar.
Prior to this, well, myself was with Justice Goswami. In the
We'll have to
active
find it out. Lordship.
There are many judgments we have,
Yes,
and those have been upheld by the apex court. That's the reason we're asking.
okay.
Myself with Honorable Justice Goswami, as he was then,
We-
passed the deal on these matters that were upheld by the apex.
We will look into those also, Lordship. This also says the impugned judgment reflects this fact which stated that even after being given ample opportunities to adduce evidence, the petitioner did not adduce any evidence before the learned tribunal. Now, when the petitioner was arrested and put in a detention camp, then only he filed this writ petition. So it is clear on the face of the record that there was utter negligence on the part of the petitioner. The petitioner did not exercise due diligence. Here also, they know about this proceeding, and in spite of that, the delay factor has been taken into account, Lordship.
Okay. Okay, this will be- MS, you are pending counsel from Department of Assam for the rest number 2, 6 and 7. Mr. AIL is pending counsel election commissioner we get for the district. And Mr. P. Sharma. Additional senior government of Assam for the rest of the 5. itu di will pass the order. I don't know.
Wait, please, your lordship. Here in this case, lordship, the
The husband of the petitioner is in custody, Lordship, and one detention order was passed. And that your Lordship will find at page 44.
You have submitted a representation. What about, what happened to that representation?
That representation was rejected, Lordship. Because here your Lordship will find that page 44 detention order was passed on 18th April 2023. And admittedly, this was supplied to the petitioner on 8th May 2023. That your Lordship will find at page 49. There, page 49. This is the letter of jailer, Lordship, who served the copy up on the detainee. And in page 44, your Lordship will find there mention about two cases. In one case, he was prior to this detention order, he was on bail. And in second case, he is already acquitted. His bail application was not pending at the moment when this order was passed. My first ground is that regarding delay in serving the copy of the detention order as well as grounds. And my second ground of challenge is that, Lordship, while passing the impugn order, they relied on police report, but they have not furnished those copies to the detainee, Lordship. And my third ground is that, Lordship, when the detention order was passed, there was no likelihood of releasing him on bail, Lordship. That satisfaction is required, Lordship.
Your second ground is that you have relied on the police report.
Police report. And they have not furnished the said documents.
Order is detention order not furnished in time.
Yes.
What is the third ground you have?
Third ground is that there was no likelihood of releasing him on bail at that when this detention order was passed. Because in first case, he was already on bail, and in second case, he has not filed any bail application. My first ground that delay in serving the copy, Lordship, that itself is in section 3, subclause 3 of preventive detention, Lordship. That has to be served within 5 days and with reasoning within 10 days, Lord. And here, admittedly, the order was passed on 8th April, and they have served the copy on 8th May. That is beyond 15 days.
Out of the two police cases, NGPS cases, in one you have been granted bail.
Yes,
Right.
prior to
Which date?
passing of the impugn order.
Which date?
Lordship, that just I have enclosed here. Your Lordship will find at page 56. Date of order is 1/10/2021.
Yes, Mr. Nath, how do you File an affidavit.
Yes, my lord, we have filed the affidavit. But the first ground taken by them that the copy has been served late, my
On
lord,
age.
on 8th May. That we have explained in paragraph 6, my lord. Paragraph 6 of our affidavit, my lord. But the detention order was issued, it was issued by the detaining authority on 18/4/23, but it was executed on 8/5. Paragraph 6, my lord. The deponent begs to state that the detention order dated 18/4/2023 was executed and served upon the petitioner's husband detainee on 8/5/2023, while service report dated 12/5/2023 issued by the Super SP Karimganj. The contention of the detainee that he was not served the detention order and grounds of detention on the same day of his detention is denied on the premise that the detention order dated 18/4/23 and the grounds of detention dated 18/4/23 was served to him upon his detention, which was executed on 8/5/23, as per the service report of the SP. That we have annexed. In fact, the petition has also annexed in the writ petition. As such, the provision under section 3(3) of the P&DPS Act 1988 has not been violated. As informed by the SP Karimganj by this letter number so-and-so dated 13/10/2023, the detainee was in judicial custody and was detained under P&DPS Act 1988 in pursuance of detention order dated 18/4/23, which was served on him on 8/5/23 by SP Karimganj letter dated 6/5/2023, and the grounds of detention was also served on 8/5/2023. The grounds of detention were duly informed to the detainee on the day of execution of the detention in compliance with the provisions of section 3(3) of the P&DPS Act 1988. Subsequently, he submitted a representation on 27/5/2023. It was duly examined in the light of the relevant records and police report, along with the representation submitted by the SP Karimganj via his letter dated 9/6/2023, and upon finding no grounds for revocation of the detention order, the representation was rejected and disposed of by order number so-and-so dated 13/6/2023, that is Annexure 6 to the writ petition.
This is one you are saying that, but why it will not come under section 3(3)? Let's read section 3.
Logic. No. Let me. For the 3(3), my lord.
3 is
3. 3 is power to make order detaining certain persons. 3(3) will be for the purpose of clause 5 of Article 22 of the Constitution.
3, yes.
3(3). For the purposes of clause 5 of Article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not less than 5 days, and in exceptional circumstances and for the reasons to be recorded in writing, not later than 14 days from the date of detention. Well, here we have said that although the
Let us see Annexure 8.
logic. But kindly come through
Till 77.
the original lordship will find at page 86. This is the 78 is the type copy. 77 and onwards, these are type copy.
Yes, please read.
Logic. Well, the 86 is the letter by the SP to the secretary, my lord, after execution. This is the report 12/5/2023. In inviting a reference to the subject cited above, I have the honor to submit the service report of detention order under P&DPS Act in respect of under trial prisoner Asad Uddin, aged 56 years, son of so-and-so, resident of so-and-so, after obtaining his signature on the body of the detention order and notice duly identified by assistant jailer for favor of your kind in perusal and information. The next page, kindly see, my lord. This is by on 6/5/2023 by SP Karimganj to the Superintendent of District Jail, my lord. Detention order under PWDPS. In inviting a reference to the subject cited, I am forwarding herewith a copy of the order under PWDPS Act 1988 dated 18/4/23 along with notice received from the Secretary to the Government of Assam Home and Political Department Dispur for detention of Asaduddin aged about 56 years. So and so, below. Next page, kindly see. Page 88. This is the order. This was received by. This is the detention order. It was executed on the husband of the petitioner on 8/5/2023. At the below bottom, my lord, lordship will find the signature of the signature of Asaduddin, and this signature has been attested by the assistant jailer, my lord. So the detention order has been executed on this day, and if lordship kindly goes with the provisions of section 3(3), my lord. For the purpose of clause 5 of Article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds. Well, the detention order has been passed and the ground has to be communicated within 5 days. On which the order has been made shall be made as soon as maybe after the detention, but ordinarily not later than 5 days.
So you have two grounds. It
Lord.
has to be only after detention. That is
After
fine.
lordship,
Secondly, 5 days, and if it is not under 5 days, then it is with reason.
with region. But we said that the detention order has been executed on 8/5, and in fact the grounds has been served not within 5 days. That is on the same day.
You are saying that detention order has been issued on
18
8/5.
18/4. It was by the secretary.
Right.
But-
18/4 is the order,
It is 18/4 is the order.
and detention is on 8th of May.
8th of May.
So within 5 days of the detention. So
Of the
within
detention.
13th of May,
Yes, my lord.
and it was served on him on
On same day, on 8/5,
8 itself.
8 itself.
So according to you, the page number 87.
Page number 80, my lord, 7 is the it was the
Order of detention by
it-
the Superintendent of Police.
it is
Karimganj.
lordship. It is the SP Karimganj has forwarded the detention order as received from the secretary on 6/5/2023. This later is written, my lord.
Mm.
It was given to the Superintendent Karimganj for execution. Then on 8/5/2023, the jailer has executed the order on and given the copy on 8/5/2023. This is the order, 18/4/2023 order. This is the detention order. And kindly come to page 90. This is the grounds. These are the grounds, my lord, under which he was detained. This was also given to the petitioner on
8th
the
of
husband
May
of the
itself.
petitioner on
On the date of
8/5/2023
detention.
on the date of detention. So as per the provisions, my lord, from the date of the detention, within 5 days, we have to give him grounds. So it is well within that, my lord.
Yes, Mr. Raja, what do you have to say now? Because currently the date of detention is 8th of May.
Lordship.
Well,
Order was passed on 12th of April,
Lordship.
but the order of detention is the 8th of May. And subsequent 3 of section 3 of this 1988 Act.
Lordship.
It's clear from the date of detention.
Lordship.
5 days from the date of detention.
Detention.
If it is not served within the 5 days,
Lordship.
then with reason.
Lordship.
What do you have to say in this letter?
Uh,
You want to say that you have been detained earlier prior to it?
I was in
12th of April
custody.
is that was a different case where you have not sought for any bail.
Lordship.
You have been detained in a particular police case.
Lordship.
In the PS case, you have been detained. In other case, you have already obtained bail. Now, this detention of
Lordship.
in terms of the order of 12th of April.
Lordship.
Issued by the secretary.
Lordship.
1980 Act. Was executed on 8th of May. Now, if you go through subsection 3 of section 3, it is clear
Lordship.
from the date of detention.
I will reply to that, Lordship, but I have two other grounds also, Lordship. That non-furnishing of police report to the detainee. That although in the order, your Lordship will find page 44, first paragraph.
Yes.
Whereas a police report has connected records have been laid before the undersigned. So police report was considered.
Hmm.
So those reports were not furnished to the detainee lordship. And in this regard, lordship, just I am relying on judgment of our High Court. First one is lordship Sylvester Nursery. Paragraph 10 and 11, lordship.
And other judgment, para 4.
And second judgment, lordship, on the point that there was no likelihood of releasing him on bail. Para 6 and 7.
Yes, Mr. Nath.
But as regard the second ground of non-furnishing of the documents,
No,
but I,
apparently from the reasons that it page 46, which are the grounds of the detention.
but my submission would be, my lord, the position is very clear, my lord. I would like to refer to the decision of 2009, 1 SCC, page 333, my lord. Here, the position is very clear.
2009.
2009, 1 SCC, 333. This is a case of state of Tamil Nadu and another versus Abdullah Kadir Badsha. Well, there I am.
Just a minute.
Lordship.
Paragraph.
Para 5, 6, 7, 8, 9, my lord. I'm reading, my lord, para 5. In support of the appeal, it has been stated that the documents in question which were requested by the detainee to be supplied had nothing to do with the order of detention. It was pointed out that there is a difference between the narration of facts and the ground of detention.
Just a minute.
Lordship. Para 5.
This is a trivial judgment.
Yes, my lord.
Yes. Good.
In support of the appeal, it has been stated that the documents in question which were requested by the detainee to be supplied had nothing to do with the order of detention. It was pointed out that there is a difference between the narration of facts and the grounds of detention. Undisputedly, a copy of the order in the writ petition which was sought was in fact supplied though at a later point of time. It is not understood as to how the order passed in the writ petition was, which was dismissed can be a document about which the detainee had no knowledge. The High Court erroneously came to the conclusion that the relied upon documents were not supplied. I'll place reliance on this thing, Lord. Actually, the factual scenario is just to the contrary, as rightly contended by the learned counsel for the state. The documents were read over and an endorsement to the effect has been made by the detainee. In Radhakrishnan Prabhakaran versus State of Tamil Nadu, it was observed as follows. We may make it clear that there is no legal requirement that a copy of every document mentioned in the order shall invariably be supplied to the detainee. What is important is that copies of only those documents as has been relied on by the detaining authority for reaching the satisfaction that preventive detention of the detainee is necessary shall be supplied to him. It is admitted by the learned counsel for the petitioner that the order granting bail has been supplied to him. Application for bail has been submitted by the detainee himself when the order of detention was passed, which was subsequent to the order granting bail. We cannot comprehend as to how a prior order rejecting bail would be of any relevance in the matter when it was later succeeded by the order granting bail. But the learned counsel emphasized that the counter affidavit by the department was a relevant document, a copy of which has not been supplied to him. The view in Radhakrishnan Prabhakaran case was reiterated in J. Abdul Hakim versus State of Tamil Nadu and Sunila Jain versus Union of India. The court has a duty to see whether the non-supply of any document is in any way prejudicial to the case of the detainee. The High Court has not examined as to how the non-supply of the documents called for had any effect on the detainee or whether the non-supply was prejudicial to the detainee. Merely because copies of some documents have been supplied, they cannot by any stretch of imagination be called as relied upon documents. While examining whether non-supply of a document would prejudice a detainee, the court has to examine whether the detainee would be depriving of making an effective representation in the absence of a document, primarily the copies of which form the ground of detention are to be supplied, and non-supply thereof would prejudice the detainee. But the documents which are merely referred to for the purpose of narration of facts in that sense cannot be termed to be documents without the supply of which the detainee is prejudiced. But in the repetition, Lordship will find that there is nothing on the part of the petitioner that this document was not given. That is why we could not file an effective representation. In fact, it is the case of the petitioner in this case herein that representation has been filed without application of mine. It has been rejected. No, nothing has been stated as regard prejudice. How the petitioner has been prejudiced from not giving of the documents. And that report, if kindly the grounds page 46, my friend has relied. Kindly see below the documents which were referred, which were relied by the authorities for their satisfaction, those have been given. Page 46, kindly see the last sentence. Photocopy of the FIR, FSL report, seizure memo, GD entry, GD extract copy, counterfoil of charge sheet are annexed. Those are given to him. He has received these copies. In respect of the second case also, those are given. These are the documents on the basis of which the satisfaction, the authority has drawn their satisfaction that detention is required. Those are given.
Mr. Azad, you were granted bail in which case, 213/2021 or the first one or the second one?
In first one, 213 of 2021. In second case, I am acquitted.
And you were in custody in the second case.
No, yes, at that point of time.
Well, as regard the that ground, Malad, likely to be released on bail, Malad, kindly come to page 48. They have applied their mind, Malad, the authority. At present, you are in judicial custody, and it is likely that you may be released soon in connection with Karimganj PS case numbers 1, Karimganj PS case number 213/2021. Here, Malad, according to him, he has got bail. Karimganj PS case second is Karimganj PS case number 496 of 2021. Here, Malad, subsequently he has been acquitted after detention. So, Malad, one in Bay he got bail, in the other he has been acquitted. So they said that your release on bail appears to be seriously detrimental to a large number of people of Karimganj district. Your release may again lead to restart the illegal business of drugs in the district of Karimganj, as you are one of the main conduits, though through whom drugs are supplied to the district. Your detention is also necessary so that other drug traffickers are also debarred from peddling drugs to protect the younger generations of the state from the menace of drugs in the district of Karimganj. So this is the satisfaction, and prior to that also, Malad, in the order from page 46, 47, their satisfaction they have noted, Malad. Kindly see, Malad, in the page 46, the second paragraph, they have referred that these are the case, this is you have done, and they come to know about this from the police records. It is learned from police records that you started illegal trafficking of narcotic and psychotropic drugs as drug peddler for last several years. Further, you are associated with various other cases. You were involved in Karimganj PS case number 496/2021. He has been acquitted there, and Karimganj PS case number 213 of 2021. He got bail there. Of Karimganj police station, the district police has already registered 2 numbers of cases under NDPS Act, and during investigation it is found that you were involved in the business of drugs. It appears from the record that on 18/5/2021 at about 5 p.m. information received regarding illegal selling of drugs, brown sugar, by you. The investigating officer conducted raid and search operation at the place of occurrence in presence of witnesses. During search, police recovered 330.46 grams brown sugar on 18/5/2021 from your possession in connection with Karimganj PS case number 496/2021.
In this case, he has been acquitted.
He has been acquitted.
And that order is not challenged to my information.
No, we have not challenged. Malad, preventive detention is not to punish. Preventive detention is to prevent from indulging in the same,
In
matlab,
the society,
yes, my lord.
disappearing the society.
Yes, yes,
that's
yes. This is position is very clear, my lord. 2012 2SCC 389.
2012.
2012 2SCC 389. Honorable Court has already explained that preventive detention is not to punish.
289.
2389.
2389.
No, my lord. 2012 2SCC 389. Preventive detention is not to punish,
Not to punish.
but to prevent the person from doing the same act, repeating the same. Then, my lord, during investigation, you were arrested on 19/5/2021 at 10 a.m. in connection with the case, and after proper interrogation, it was found that you were engaged in drug peddling all over the area. In course of investigation, evidence against you and your compliance were found, and on completion of investigation, charge sheet was submitted against you and your accomplices in Karimganj PS case number 496/2021. The photocopy of FIR, FSL report, seizure memo, GD extract copy, counterfoil of charge sheet, all are annexed and marked as A, B, C, D, E, and those were given to the petitioner. Next, it appears from the record that on 22/2/2021 at about 9 a.m., information received regarding illegal selling of drugs of brown sugar by you in connection with Karimganj PS case number 213/2021. The investigating officer conducted raid and search operation at the place of occurrence in presence of witness. During search, police recovered 25.14 grams brown sugar on 22/2/2022 from your house in connection with the case. During investigation, you were arrested on 19/5/2021 at 10 a.m. and after proper interrogation, it was found that you were engaged in drug peddling all over the area. This refers to Karimganj PS case number 213/2021. In course of investigation, evidence against you and your accomplice were found, and on completion of investigation, charge sheet was submitted against you and your accomplices in Karimganj PS case number 213/2021. Again, the photocopy of FIR, his involvement there, FSL report, seizure memo, GD extract copy, counterfoil of charge sheet are annexed. Those are also given to him. From the above cases, Karimganj police station, with case numbers, Karimganj PS case number 213/2021 and Karimganj PS case number 496/2021, it is seen, this is the subjective satisfaction of the authority, Lord. It is seen that you have involved yourself with the crime of illegal trafficking of drugs since long in Karimganj district. You are engaged in illicit trafficking of drugs, thereby turning a large number of youths into addicts, harming not only the health and future of the youths, but also deprive the nation from quality human resource, which will have detrimental effect on the society at large, besides encouraging such addicts into other criminal activities. Further, it is observed that you were found to be a habitual offender of such illegal drugs trafficking in violation of the provisions of NDPS Act. In spite of your arrest in different cases, you neither amended your ways nor you have any remorse for your criminal acts, and you continue to get engaged in criminal activities with the help of your accomplice. At present, accordingly, that is the conclusion, Malad. And at present, you are in judicial custody and is likely, and it is likely that you may be released soon in connection with Karimganj PS case number 213/2021 and Karimganj PS case number 496/2021. Your release on bail appears to be seriously detrimental to a large number of people of Karimganj district. Your release may again lead to restart the illegal business of drugs in the district of Karimganj, as you are one of the main conduits through whom drugs are supplied to the district. Your detention is also necessary so that other drug traffickers are also deterred from peddling drugs, to protect the younger generations of the state from the menace of drugs in the district of Karimganj. It is therefore considered essential to prevent you from acting in any manner prejudicial to the repeated violation of the provisions of NDPS Act 1985 by detaining you under the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. You are, however, informed about the right to make a representation, Lord. But kindly, for a moment, take section 3 of the Act. Section 3(1), the section 3 relates to power to make orders detaining certain persons. This is a special provision, my lord. Object of the act is very important. The object says that this act, I'll take your lordship to that, my lord. The section 3 says that power to make orders detaining certain persons. One, the central government or state government or any officer of the central government not below the rank of a joint secretary to that government, specially empowered for the purpose of this section by that government, or any officer of a state government not below the rank of secretary to that government, specially empowered for the purpose of this section by that government, may, if satisfied, with respect to any person, including a foreigner, that with a view to preventing him from engaging in illicit traffic in narcotic drugs and psychotropic substances, it is necessary so to do, make an order directing that such person be detained. So this is the language of section 3, my lord. But if for a moment, my lord, lordship kindly comes to the statement of objects and reasons of the act. The purpose of the objects sought to be achieved by this act is very clear, my lord.
Page 101. Yes.
Well, the statement of objects and reasons, the act has been brought to achieve these objects. In recent years, India has been facing a problem of transit traffic and illicit drugs. The spillover from such traffic has caused problems of abuse and addiction. This trend has created an illicit demand for drugs within the country, which may result in the increase of illicit cultivation and manufacture of drugs. Although a number of legislative, administrative, and other preventive measures, including the deterrent penal provisions in the NDPS Act 1985, have been taken by the government, the transit traffic in illicit drugs had not been completely eliminated. It was therefore felt that a preventive detention law should be enacted with a view to effectively immobilizing the traffickers. The Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974 provides for preventive detention in relation to smuggling of drugs and psychotropic substances, but it cannot be invoked to deal with persons engaged in illicit traffic of drugs and psychotropic substances within the country. It was therefore felt that a separate legislation should be enacted for preventive detention of persons engaged in any kind of illicit traffic in narcotic drugs and psychotropic substances. Accordingly, the President promulgated the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Ordinance 1988 on 4 July 1988. The ordinance provides the following, amongst others things, namely, these are the
Right.
provisions for law. So, this section 3(1) provides for the satisfaction of the authority that there is possibility that with a view to prevent him from engaging in illicit traffic in narcotic drugs and psychotropic substances, if it is necessary so to do, make an order directing that such person be detained. So that application of mind is available in the order, in the grounds, lordship will find.
Come back at 2.
Lordship,
We have some meetings.
lordship,
Other meetings are there.
lordship.
So, okay, on 16th.
Okay.
Yes, Mr. Raja, just carry on.
Lordship, here, my learned friend has said that police report, regarding police report, I have not stated anything in my written petition. Lordship, may kindly see paragraph 10.
No, but even if you have not said, the report which I have asked for,
Lordship,
that you said it has not been furnished to
Lordship,
the revenue.
Lordship,
But what has been pointed out,
Lordship.
that the basis on which the order has been passed on 14th of April, 18th of April, is on the basis of the police report means the case diary and other material.
No, I'm coming to that. I'm coming to that, Lordship. I'm straightway coming to that. Lordship, may kindly see that impugn order itself, page 44. Again, I'm taking your Lordship to that.
Yes, yes.
So my learned friend has mentioned about FIR, FSL report, those things. But if your Lordship see the last paragraph. But before the Lordship, first paragraph, I'm reading entire paragraph first. Whereas a police report and connected records, two things, Lordship. One, police report and connected records have been laid before the undersigned by the Inspector General of Police, Assam by letter number so-and-so dated 2/6/2019 and letter number so-and-so dated 21/9/2022. Lordship, may I note the dates because it will, I will refer to it later, Lordship. And crime number so-and-so letter dated 30/11/2022 of the Superintendent of Police, Karimganj. Now, Lordship, may kindly say the last paragraph. Whereas I, Shiladitya Setia, IPS, Secretary to the Government of Assam Home and Political Department and Detaining Authority under PIT NDPS Act on perusal of the police records and recommendation of the Inspector General of Police. So there are some other documents also. And Superintendent of Police, Karimganj, I am satisfied that Asaduddin so-and-so. So those things were, Lordship, considered. And here your Lordship will find, in a manner prejudicial to the provisions of the NDPS Act by continuously indulging in illicit trade or in narcotic drugs, even after his arrest several times. Several times, Lordship, he was not arrested. And now I am again taking your Lordship to paragraph 48. Page 48, sorry, page 48. That paragraph 6. The language I am reading, placing before you. At present, you are in judicial custody. That is right. It is likely that you may be released soon in connection with the Karimganj PS case number 213 of 2021. He was already released. That report is not correct. Karimganj PS case number so-and-so. So other, I am not saying, because in case of other case, I have not filed any bail application when this detention order was passed. For more than 1 year, I have not filed.
This 496/2021, you have already been acquitted.
Yes, acquitted.
On which date?
After that, this impugn order. After impugn order.
Okay.
But I have my bail application was not pending. I was already in detention. So they have to record what was the necessity, because I'm taking your Lordship to again that section 3 subclause 1. Your Lordship will find that necessity word is there. They have to show the necessity because I was already in detention. And as your Lordship aware that section 37 is already there. There is a bar in granting bail. So what was the necessity to pass the impugn order? So I am again taking your Lordship to section 3. The central government or a state government or any officer of the central government not below the rank of a joint secretary to that government, specifically empowered for the purpose of this section by that government, or any officer of a state government not below the rank of a secretary to that government, especially empowered for the purposes of this section by that government, may, if satisfied. So first he have to be satisfied with respect to any person, that with a view to preventing him from engaging in illicit traffic in narcotic drugs and psychotropic substances, it is necessary so to do. So now this word comes, Lordship, it is necessary so to do. I am already in detention. My bail application is not pending. What was the necessity? So that satisfaction is not there in the impugn order. And what they have said that there is a likelihood of releasing me in connection with 213/2021. I was already on bail. Their report was incorrect. The police report which they were relying on. About 2 years back, I was granted bail. 1 year back.
Where is that bail order?
Bail order, your lordship will find at page,
Acquittal order is at page 25.
lordship, and bail order is page 56. This was passed on 1/10/2021.
Anything else?
And then your lordship, that necessity is not there in the impugn order, that page 44, your lordship will not find that satisfaction. That what was the necessity? Because I was already in custody in connection with Karimganj PS case number 496, 2021. And even in my representation, I have clearly said that I have not filed any bail application. My bail application is not pending. So that was also not considered while confirming that detention order. Because they have to satisfy that there is a chance of releasing him on bail. That judgment which I have placed before your lordship. That 1986, that judgment. Binod Singh, lordship. Paragraph 6 and 7. Because of that word necessity, that they have to satisfy.
No, you have placed Sylvester Nursery and
Binod Singh.
Karnataka State Tourism.
Binod Singh,
Sorry,
Binod Singh.
Singh.
Yes.
Paragraph 6 and 7.
1986,
That's right,
486,
that's right.
416. Paragraph 6, I am reading lordship, paragraph 6 and 7. In this case, there were grounds for the passing of the detention order, but after that, the detainee has surrendered for whatsoever reasons. Therefore, the order of detention, though justified when it was passed, but at the time of service of the order, there was no proper consideration of the fact that the detainee was in custody or that there was any real danger for his release. Nor does it appear that before the service there was consideration of this aspect properly. In the fact and circumstances of this case, therefore, the continued detention of the detainee under the Act is not justified. It is well settled in our constitutional framework that the power of directing preventive detention given to the appropriate authorities must be exercised in exceptional cases, as contemplated by the various provisions of the different statutes dealing with the preventive detention, and should be used with great deal of circumspection. There must be awareness of the facts necessitating preventive custody of a person for social detention. If a man is in custody and there is no imminent possibility of his being released, the power of preventive detention should not be exercised.
But Mr. Azhar,
Lordship.
relying that is a judgment passed by two honorable judges of the appeal court. Now we have a judgment which has been placed by Mr. Nath.
Lordship.
That's a three judges judgment
Lordship.
relating to State of Tamil Nadu versus Abdullah Kader Bacha. That's reported in 2009, 1 SCC 333. Now, if you read para 7, do you have a judgment?
Yeah.
Can you ask Mr. Azad to read? If it is in your, okay. Okay. Read para 7, straight away.
The court has a duty to see whether the non-supply of any document is in any way prejudicial to the case of the detainee. High Court has not examined as to how the non-supply of the documents called for had any effect on the detainee and or whether the non-supply was prejudicial to the detainee. Merely because copies of some documents have been supplied, they cannot by any stretch of imagination be called as relied upon documents. While examining whether non-supply of a document would prejudice a detainee, the court has to examine whether the detainee would be deprived of making an effective representation in the absence of a document. Primarily, the copies which from the ground for detention are to be supplied and non-supply, therefore, thereof would prejudice the detainee. But documents which are merely referred to for the purpose of narration of facts in that sense cannot be termed to be document without the supply of which the detainee is prejudiced.
Now, if you come to page number 47. There are 5.
Lordship.
That it starts with it is sealed. That has been indicated to you.
Lordship.
Now, let us read, kindly read that paragraph.
Lordship, it is seen that you have involved yourself with the crime of illegal trafficking of drugs since long in Karimganj district. You are engaged in illegal trafficking of drugs, thereby turning a large number of youths into addicts, harming not only the health and future of the youths, but also deprive the nation from quality human resource, which will have a detrimental effect on the society at large, besides encouraging such addicts into other criminal activities. Further, it is observed that you are found to be a habitual offender of such illegal drugs trafficking in violation of the provisions of NDPS Act. In spite of your arrest in different cases, you neither mended your ways nor you have any remorse for your criminal acts, and you continue to get engaged in criminal activities with the help of your accomplices. So now here your lordship will find they have said that in spite of your arrest in different cases, you neither mended your ways nor.
Come to page number 48.
Lordship.
Read that para also, para 6.
Para 6.
But first few 4 lines are not required. But anyway, you read it. Kindly read.
At present, you are in judicial custody and is likely to that you may be released soon in connection with the Karimganj police station case number so and so, Karimganj PS so and so. Your release on bail appears to be seriously detrimental to a large number of people of Karimganj district. Your release may again lead to restart of the illegal business of drugs in the district of Karimganj, as you are one of the main conduits through whom drugs are supplied into the district. Your detention is also necessary so that other drug traffickers are also deterred from peddling drugs to protect the younger generations of the state from the menace of drugs in the district of Karimganj.
So that is the reason why the authority concerned considered to put you under detention under the 1988 Act.
But
That's
my-
the reason.
But
they have.
Lordship,
But you are saying that other 2 particular documents on the basis of which the authority concerned have considered and decided to put you under detention.
they want to show my background through those police reports. Because in these 2 cases, one I am already in bail and in other case I got acquitted. And they are saying that I am peddler. So that report they want to say. They want to say that I was involved in other cases also. since long. So what was that report? They have to disclose it. If there is no case, then they cannot say that I'm involved in other case since earlier. And they said, Lordship, there is that you may be released soon in connection with Karimganj PSC. So from where they got that satisfaction? Because my bail application was not pending. My last bail application was rejected in the month of March 2022. And they have written this in April 2023, after about 1 year, more than 1 year. During this period, I have never filed any bail application. I was facing the trial. From where they draw that satisfaction that I will be released on bail? That fact is not there in the impugn order. Because they have to draw satisfaction and the necessity. And their report says I may be released on that PS case 21321, but I was already on bail. Their report is not correct. And the second case where, Lordship, I was not on bail, that was under commercial quantity. So section 37 is there. So there was no chance of releasing him on bail. So they have to also address that aspect also, that even after 37, how I will be released on bail. That satisfaction is not there in the impugn order. So there was, my altogether submission is that there was no chance of releasing him on bail. In spite of that, this order was passed. Without showing any necessity for his detention. And the judgment below which I have placed your Lordship, the exact word, just I am reading one line, Lordship. If a man is in custody and there is no imminent possibility of his being released, the power of preventive detention should not be exercised. I have faced the trial. I have now I am acquitted, but because of this order, I am in custody. And that order is not challenged by them. So that is Lordship, binding to them, that I am not involved in that case.
What is the status of the other police case, NDPS case?
Other case, Lordship, charge sheet submitted, but probably trial not concluded yet. I am in custody, so
Please come to page number 64.
In this case, I am acquitted,
Page number 64,
Lordship,
the second last paragraph.
Lordship,
It is to be noted.
Lordship.
And it is
It is to be noted that earlier on 21/2/2021, his house was searched and recovered 25 grams of narcotic drugs by me and my team and apprehended his son Imran Hussain and said accused Asaduddin has absconded, seeing the police party approaching his house. So this is the second case which is mentioned, Lordship,
which is now pending.
which is pending.
Please proceed.
I lodged an Azahar at Karimganj PS case against the said accused Asaduddin, and the case has been registered by Karimganj PS case number so and so. It is learned that accused Asaduddin is also a professional drug peddler. He is involved in other criminal cases too, and other NDPS Act cases is also pending for trial against him. During preliminary interrogation, he revealed that the seized suspected to be narcotic drugs were handed over to him by one Shihab from Nigram, whose contact number so and so. So all these allegations are found to be not believable. Therefore, he is acquitted.
No, this is in the other, which is pending.
No,
The other case.
page 64 is the FIR where I got acquitted.
Page 64 relates to the affair where you got.
Down below your lordship will find case number, PS case number 496/21.
That's the affair.
Lordship.
Yes, Mr. Nath, what do you have to reply?
But
Apparently, these two documents haven't been furnished to the detainee, right?
Gotcha.
But
Right.
leaving aside that,
his acquittal, one thing Lordship may kindly consider, his acquittal is because the prosecution failed to prove the allegations,
for technical
charges
reasons, let us assume it for technical reasons.
beyond reasonable doubt. That doesn't say that he is not at all involved. The honorable court has given him a clean sheet, and which is not required, my lord, in fact, for passing a detention order under this act. Lordship, I have already placed reliance on the judgment, the earlier judgment, my lord. And that Lordship has already taken note of 2009 1 SCC, page 333. But I would like to also refer to 2017 1 SCC 757. Two 2017 1 SCC 757. And the other decision which I have already said, my lord, 2012 2 SCC, page 389. These are, my lord, this 2012 which I have already submitted to 2012 2 SCC 389. It is on the subjective satisfaction of the authority, on the point of subjective satisfaction. Kindly see, my lord, para 10, 11, and 22. Para 10, 11, I'm referring to 10, 11, and 22. No? Submissions are being made that since he has been acquitted in the criminal trial, so he is not at all involved in such cases. But in fact, the purpose of the detention law is something different. I'm reading para 10 law. If the government public detaining authority is able to satisfy that a person either by himself or in association with other members habitually commits or attempts or abets such commission of offense punishable under IPC, the AP Act and the rules subject to satisfying section 3 of the 1986 Act, he can be detained in terms of the said Act. The essential concept of preventive detention is that the detention of a person is not to punish him for something he has done, but to prevent him from doing it. Even as early as in 1975, a constitution bench of this court considered the procedure to be followed in view of Article 19 and 21 of the Constitution. In Haradan Saha versus West Bengal, a constitution bench of this court, on going through the order of preventing detention, under the Maintenance of Internal Security Act to 1971 laid down various principles which are as follows. Firstly, because a detainee is liable to be tried in a criminal court for the commission of a criminal offense or to be proceeded against for preventing him from committing offense dealt with in chapters 8 of the Code of Criminal Procedure would not by itself debar the government from taking action for his detention under the Act. Second, the fact that the police arrest a person and later on enlarge him on bail and intimates and initiates steps to prosecute him under the Code of Criminal Procedure and even lodges a first information report may be no bar against the district magistrate issuing an order under the preventive detention. Third, where the person concerned is actually in jail custody at a time when an order of detention is passed against him and is not likely to be released for a fair length of time, it may be possible to contend that there could be no satisfaction on the part of the detaining authority as to the likelihood of such person indulging in activities which would jeopardize the security of the state or the public order. Fourth, a mere circumstance that a detention order is passed during the pendency of prosecution will not violate the order. Fifth, the order of detention is a precautionary measure. It is based on a reasonable prognosis of a future behavior of a person based on his past conduct in the light of the surrounding circumstances. Now let's finally come to para 22. In a matter of detention, the law is clear that as far as subjective satisfaction is concerned, it should either be reflected in the order or in the affidavit justifying the detention order. Once the detaining authority is subjectively satisfied about the various offenses leveled against the detainee, habituality in continuing the same, difficult to control him under the normal circumstances, he is free to pass an appropriate order under Section 3 of 1986 Act by fulfilling the conditions stated therein. We have already concluded that there is no infirmity either in the reasoning of the detaining authority or the procedure followed by it. But this is in respect of that particular case. But the law is already the Honorable Court has stated. Logic. But the other case which I am relying on in 2017 1 SCC 757. This is on both the points, on subjective satisfaction of the authority as well as the non-furnishing of the documents. In fact, non-furnishing of the documents, what I have already submitted, that position is also maintained here. That all the documents which are mentioned need not be given. The relied documents are only to be served. Two 2017 1 SCC 757, my lord. Lordship will find. I'll take your lordship straightway to para 15, my lord.
Yes.
Lordship. But I'll just give a reference to para 10, 11, 12 because the non-submission of documents lordship has to examine. Already that law is settled in the other decision that the petitioner has to show how he is prejudiced by non-submission of the document. Well, in the entire writ petition, even in the representation also, there is no whisper that you have not given me this document, so I am restrained from making a proper representation. There is nothing. This is a ground taken only in this petition. Para 10, just I'm reading. Reliance was placed by the learned counsel for the petitioner on State versus Tamil Nadu versus Abdullah Kadir Badsha. In para 7, the court observed us. The court has a duty to see whether the non-supply of any document is in any way prejudicial to the case of the detainee. The High Court has not examined as to how the non-supply of documents called for had any effect on the detainee and or whether the non-supply was prejudicial to the detainee. Merely because copies of some documents have been supplied they cannot by any stretch of imagination be called as relied upon documents. While examining whether non-supply of a document would prejudice a detainee, the court has to examine whether the detainee would be deprived of making an effective representation in the absence of a document. Primarily, the copies which form the grounds of detention are to be supplied, and non-supply thereof would prejudice the detainee, but the documents which are merely referred to for the purpose of narration of facts in that sense cannot be termed to be document without supply of which the detainee is prejudiced. So that is specifically my argument here, Madam. There is no statement in the writ petition that this document has been not been given and I haven't prejudiced. Now kindly come to para 15, Madam. From the plain language of the impugned detention order has been quoted, Madam, in the previous para. It is seen that the state government order dated 18/10/2015 is an order issued by the state government authorizing or delegating power to the Commissioner of Police (TNI) to issue order under Section 3(2) of the 1982 Act. The question is whether it was mandatory for the detaining authority to supply a copy of this government order to the detainee. They say that this particular order authorizing the officer was not given to him. The order having been issued in exercise of power conferred under Section 3(1) of the 1982 Act and being a statutory order had nothing to do with the grounds of detention. What is imperative is to supply all the documents which are relied upon by the detaining authority for forming subjective satisfaction for the purposes of Article 22(5) of the Constitution of India. The government order, however, is regarding the delegation of power to the Commissioner of Police to issue detention order. The validity of that order has not been challenged by the petitioner. In our case, Mulad, the power of the detaining authority has been challenged. I'll take your lordship to that paragraph. In other words, the power of the Commissioner of Police, Greater Chennai Police, Chennai, to pass an order is not put in issue. The state government order is not relevant for forming subjective satisfaction by the detaining authority. The grounds of detention are about the prejudicial activities in which the detainee had indulged in past, or in that view of the detaining authority, the detainee has the propensity to indulge in similar prejudicial activities even in future. That is the quintessence for exercising power to detain any person. Suffices to observe that the subject document not being the relied upon document in the grounds, the detention or for forming subjective satisfaction by the detaining authority, failure to furnish copy thereof to the detainee does not vitiate the action taken by the detaining authority. So, my lord, the detaining authority has to submit the document on the basis of which he forms his opinion, and the detaining authority has to see that the ground of detention are about the prejudicial activities in which the detainee had indulged in the past. So these are in the ground he has mentioned, the detaining authority in our case has mentioned that these are the action you have indulged. Or in view of that detaining authority, the detainee has the propensity to indulge in similar prejudicial activities in the future. So that is the subjective satisfaction that has been recorded in the order. And accordingly, the order has been passed. Well, in the writ petition, there is no statement, nothing has been stated as regards prejudice caused to him because of non-furnishing of the document.
Paragraph 10 Lordship, of my writ petition.
Para 12, kindly see, Lord, the authority of the the power of the authority has been challenged. They said that he is not the authority competent under Section 3(1). They said that the Secretary to the Government of Assam, Home and Political Department, Dispur, Guwahati 6, who is the detaining authority, in the instant case has no authority under the law and also has not even been empowered under Section 3(1) of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 85 to pass the order of detention. The power of the authority has been challenged.
And in paragraph 52, page 52, your lordship will find that in the representation also he disclosed that he has not received the police reports and some of the documents are illegible. Page 52, last paragraph your lordship will find. Furthermore, your lordship will find page 52. When it is said illegible, so nothing further is required. They can very well verify for the documents because he was in custody and documents were there with him.
This ground of मतलब the eligible documents, this has been already taken care of in 2017 1 SSC 757.
From the submission which my learned friend has made, I could understand, subject to correction, that the documents which were relied on for to draw the satisfaction, those documents has to be furnished. And here I have placed before your lordship that page 44 clearly says that from perusal of the police report, letter of the SPs, and thereafter the other records, the satisfaction was drawn. Page 44, last paragraph, it will show. So those documents were taken into consideration while forming that while drawing that satisfaction. So those judgments even helped me.
There is no police report in the last paragraph. It says police records.
On perusal of police records and
Records.
recommendation of the Inspector General of Police. So what was the recommendation? Those letters were not given to him. And the Superintendent of Police Karimganj, I am satisfied. So these 3-4 documents were considered. Not the FIR, not those things. And I'm again stressing on the point of necessity, Lordship, that section 37 was there, I was in detention. So what was the necessity? That necessity is not there in the impugn order. If it is allowed to pass order without disclosing that necessity, Lordship, then in that case, no person will come out from jail even after getting acquittal from courts.
Anything else you want to explain further?
This was my argument.
Mr. Nath,
Lordship.
anything you want to add?
my lord, I my lord, nothing, my lord, the main grounds now urged by the petitioner, although in the writ petition, some other grounds have been taken, we have dealt with in the affidavit.
No, he has four grounds.
Lordship.
One is the delay.
Lord.
Second, there was no bail application pending.
Lord.
There was no necessity to put him under detention.
My lord.
And thirdly, that court has not been followed. Documents not be given.
Lordship.
And the other ground is that delay which you have clarified under section 3.
Lordship.
That is only 5 days. In the
Yes.
detention. But what we have said that the order was of April, but we have served him only on 8th of May.
8 of
That ground, Mr. Azad is not pressing. hard.
Lordship.
The other three grounds mostly. is-
Lordship. On documents, my lord, I have already made the submission. Referred, relied upon documents have been given to him. Entire thing has not, is not required to be given. That I have submitted.
Just Lordship will, just one thing, Lordship.
Hmm.
That paragraph 44, last paragraph may be considered, Lordship, in, while considering that aspect of it. The page 44, last paragraph. Even if we accept that his submission that the enclosed document that which he have shown, that FIR charge sheet, page 47, all those things have been, all those things, all those records have been furnished to the detainee. Even then, Lordship, that recommendations of Inspector General of Police, Superintendent of Police, those were not given to him. Apparently, it is there. And that was considered to draw satisfaction, Lordship. So entire documents were not furnished.
Okay.
Lordship.
But Mr. A.K. Azad, Learned Counsel Academy. And Mr. T. Nath. Senior Government,
Lordship.
Assam. Sorry, you are appearing for whom? You are Mr. On behalf of K. Kolita. What's the full name?
For 2 to 8, I am appearing.
Place this matter for necessary order. Yeah. Sorry, 10.
10.
Friday.
Lordship.
Problem.
Available.
May I please, your lordship? Yeah, in this petition, my lordship, we have submit adjournment petition, my lord, yesterday itself, because my lord, Mr. P.K. Das, he have some medical emergency at his home, my lord. Any date after, next week, my lord?
Who is appearing for this state? You have not filed any affidavits or reply to the affidavits filed
No,
by
no,
the
sir.
respondents.
The last occasion on 2018 only, Lordship, CGC has filed affidavit opposition, my lord.
That's in
2000
December 2018.
Yes, my lord.
And then what happened?
Then matter was not listed, my lord.
That doesn't
And
mean
then-
that you will not file your reply.
My lord, we need some time, my lord.
What time, further time you can consider? This is a matter
Lordship,
of.
a short date may be
2013.
fixed, my lord. Meantime, we'll file affidavit, my lord.
Meantime, will not come.
Sorry, my
We'll have
lord.
it on 14th. 13th, 14th. There is a case in our High Court. It was revealed. There was none. This is an interesting case here where
Yes, ma'am.
the compensation has been sought for.
Yes, my lord.
This particular period was a bad phase for the BTC area. So various activities that happened, which are not like.
Honorable High Court has directed and CBI inquiry also, my lord.
Now thing is this, somebody has been killed.
Yes.
These matters didn't come out in the newspaper.
Yes, my
During the inquiry, it was revealed. And during an inquiry of similar nature, it was placed before the court.
only one person. is
Manas
left.
Sarania was for one of the petitioner. During the time when justice,
Petitioner is the only person who
as a chief justice of our High Court,
was left, my lord.
as you understand, this matter came up. While myself was, his lordship was sitting, the report was placed before the court. That's what we've been telling you. In that incident, parents of a girl were mercilessly beaten up by some persons.
Yes.
Initially, she thought it's a police or army person and was inquiring about some miscreants or some persons who belongs to another group of underground persons who were residing near their house. Parents did not reveal. She was a minor girl studying in class 8. Police left. Whoever the persons, they have been claiming it's police. They left. Second night, it was a winter night. Again, some persons came and beaten up mercilessly her parents. Then ultimately, this girl, seeing her parents suffering, revealed where those 3 miscreants are living in that village. This personnel, they are not police, they are the other group. They went and picked up those 3 persons who killed him. Police came to know, army persons came to know, they came. In retaliation of that, after the incident was over, the other group, Those 3 persons belong to that group. Those militants came, picked up that girl, placed her in the middle of a field at night in presence of the villagers. And from 4 sides, she was killed by AK-47. A girl who was studying in class 8, 9. She was a sportsman, and seeing her parents, this fact was very much kept in dark. One teacher who was a Bengali from Bongaigaon, he's a Bengali teacher, but he used to teach science or something. See, he was in Bongaigaon, but he came to know because he belongs to that village. He was feeling bad. He was asking people to raise their voice against this person's incident, where he witnesses to the incident. Then that particular teacher was again dragged and killed by the militants. This was the report placed. But we have seen none have voiced for that victim girl or victim teacher from either of the groups. That's a report, the government report. This is one incident. Similarly, Manas Sarania was also a lawyer for a particular people arrested in a connection with Dainik Link. Father was up in practicing that. He expired. The villagers were in search of his father. So ultimately, his mother and elder brother left that village. But this man remained with his father and was involved in cultivation. Since mother and his elder brother left the village and father was killed later on, this man was alone at his house. He was suffering from typhoid and high fever. He was very weak. Somehow somebody informed mother of this particular cultivator. Mother came and stayed with this boy silently and left after 3 days. Later, the villagers came to know. It's our recorded case here in our high. The villagers came to know and took him to the middle of the field and tied his both legs and hands. And people all together jointly pulled him by rope in his 2 hands and 2 legs. Each of the body parts came out from the leg because he was already weak. This is happening here. The reported case, Manas Sarania appeared for bail. He admitted it. Nobody filed any case for him.
People are scared.
Yes.
Where do you stand? Where do you stand? And this is a case here when there are fights between 2 groups of people in the name of army personnel or in the name of police. It was always happened. Always in civilian.
That too, they came in civil dress, my lord.
So we do not know.
Yes.
Only the report will reveal. But
Yes, ma'am.
in that, in both the matters, what we have been saying, reports are available. But here there is no report as such. It is the army persons are involved as of
Yes,
now.
ma'am.
So
They came in
what kind
Tata
of
Sumo, that
affidavit
is silver color Tata Sumo.
what
Yes,
affidavits will help?
This is really-
Yes,
we just- we say that
Yes,
we
L
are-
is there.
yeah.
See, we are in a society, educated society, claim ourselves to be in that stage. And it's happening, it is all files are before the court, record it. Where do you stand in a society? Think over. Develop over. So isn't it like, what about that picture? Pictures of animal, he was raising the, where is that? Where do you stand?
The people are afraid to raise their voice also against.
That's how they, because if you raise your voice, you'll be killed. So nobody will raise their voice.
Two person has already been killed, my lord. One
That's
escaped.
report, because see, we're not aware, it is not in newspapers,
Yes,
nowhere.
yes,
No social media has placed it.
yes,
It is
sir.
available on the report before the court.
Yes,
Only while going through the court, we have come to know.
yes,
That's reported.
that's it.
That's the report. Because some people were raising voice. Those three terrorists, let us assume, were
Yes.
killed by personnel from other group. But they claim that it is police personnel who have killed them. It
Yes.
is not police personnel, because something else between two groups, as you know, at
Yes,
that
yes.
point of time in that
Yes,
area.
कितने पे होगा? 14? Oh. No, next week also. 15, 16. Oh. 16 on delegates as a 14, 15. Wednesday 15 hours. How? Hearing the night. 14 law. 14 one month. 16 on the hearing the 16 on delegates. What have you done?
Similar incident. Similar.
Oh. No.
This writ petition was filed on 18/07/2013. Praying for a direction for immediate entrustment to the inquiry with regard to unnecessary death of one, the spelling, KHWMDWAM,
Kamran Doimari.
Doimari, and Rajiv, RAJIB, Bostu Motari, and the kidnapping and assault of one, Rajkumar Rabha, by an impartial and neutral agency like CBI, and oblique court to initiate judicial inquiry in the said matter and to arrest the army personnel involved in the murder of those two victims and to pay compensation to the petitioner, and for a direction to pay compensation to the petitioner by the respondents or their family members for killing oblique murder of their son oblique brother during their custody. The respondent numbers one, 2, and 3. Including the commanding officer of 12th Kumaon region within bracket Masalpur based camp. File their affidavits. File their affidavit on 29/11/2013. The state respondents. Number four, five pilots. Affidavit on 19/12/2013 to the Superintendent of Police, Baksa Mushalpur. Later, the respondent numbers 1, 2, and 3 filed a rejoinder with regard to the inquiry report. They filed rejoinder on 15/12/2018 with regard to the inquiry report. Inquiry inquiry. The petitioners till date did not file any reply to those two affidavits as well as the rejoinder noted above. When the matter was taken up for consideration, the counsel for the petitioners prayed for time. Stating that the leading counsel for the petitioner, Mr. P.K. Das, was having some medical issues. Prayer allowed list on 14th for hearing. 14.
Obliged, ma'am.
May I please, your Lordship? Lordship, in the morning, I prayed for adjournment of this matter as we couldn't contact the client. So kindly give us some time. In the meantime, we will contact the client.
From the records, it is seen that the petitioner was an employee of Indian Water. He retired from service and receiving pension. So there should not be difficulty. He is Yunus Ali, son of Muhammad Ali. Muhammad Ali,
Mohammed.
resident of Pancharatna, Govindapur, district Walpara.
District Nagaon.
He has shifted from district Nagaon to Walpara, Pancharatna, because of his service. He settled here. He submitted, the case was before the Walpara, there he has submitted all the materials. So where is the difficulty of getting any instruction from him. Matter is of 2017, madam.
Yes, Lordship, actually we are unable to contact him, that's the,
Do it whatever.
so kindly any short date may be given, Lordship, then.
We'll have it on 16th.
Okay, Lordship. Much obliged.
We have single bench, so we'll come back. Right. We'll come back at 3:45. Ma'am will to sit in her single bench. I'll also sit in the single bench. There has been mentioned before the division bench that because the cannot go parallelly.
Yes,
You have indicated something here, right? And at the same time, the matter is also pending before the division bench. So ultimately, the division bench order will prevail over this. Either you have to close it, or you have to do the review, do the division bench order, whatever is there. Both way, let us assume that the read appeal goes in your favor. This will have nothing. So you should also place it before the division bench.
Also, the matter is fixed on 28th of November.
That's
Your
true,
Lordship.
but how come this can parallelly go on?
Lord, this
cannot
date,
wait.
Your Lordship.
You have to place it.
Okay.
Then only division bench will ask certain matter. Either you place it in the review or in the division bench. Both way you cannot have, because the issue is same. This review petition is against the order. This review petition is for review of the order dated 25/11/2019. Passed in WPC number 57 of 2019. The review petitioners as appellant has also filed an appeal against the said order dated 25/11/2019. Passed in WPC number 57 of 2019. Being read appeal number
Yeah, condition of it.
27 of 2019, correct?
Yes, sir.
It is stated at the bar that the said read appeal 27 of 2019 is now fixed on
28th
28
of November, Your Lord.
on 28th of November 2023. Tell us what to do.
Lordship, we fix in the
Why
second
should we
week
fix it?
of December, Your Lordship.
This review petition shall be listed after the outcome of the division, the read appeal number 27 of 2019, presently pending before the.
obliged.
Yes, Mr. Tell us.
Lord, Mr. Gogoi told me that he will appear, he will submit. I have submitted on decision, your lordship has gone through. Only the question is regarding my lord, this was a removal from service on ground of desertion. And And only question is under section 41, the wife, he has expired in the meantime, my lord, already. Is entitled any compensation, and there is provision for granting compassionate allowance, section under rule 41 of CCS pension rule. And my learned friend, in the first time he said that he will submit one decision, but now he is also present here. Lordship is to decide only on this point. As per the decision of this, I have submitted 2014-11 Supreme Court. SCC 684. Mohinder Datta Sharma. So, Mr. Gogoi has come. So I have also have already concluded my argument.
No, Mr. Gogoi earlier placed the provision compassionate allowance when it is paid.
Plus,
And placing the same. Mr. Gogoi, anything to add?
Lordship.
That compassionate allowance under CCS rule.
Hi,
was-
Lordship.
He was considered a executive.
Lordship may remand back the matter to the authority and CS to oppose and authority will consider. Otherwise, Lordship, the regarding unfair exception, Lordship, decision of Honorable Supreme Court judgment is also there. Lordship. Even Honorable Supreme Court says it is not pardonable. Lordship. Madam may direct the authority to consider as per the Lordship Rule 41 of CCS rules to the authority and she will approach the authority. There is a when Lordship one Nishan judgment, Honorable Apex Court says that discipline is the implicit hallmark of the armed forces and non-negotiable condition of service. Lordship.
No, that's true, but
Yes.
it is this, it's up to the authority concerned,
Lordship.
the employer to decide, because it
Lord-
is may,
Lordship.
if, because that may comes because he has a family, children,
Loss.
and in that
Loss.
circumstances.
Lordship.
What is that decision you will,
That earlier one, Lordship.
no. Give us the decision that you have placed.
2014-11 SCC 648 Lordship regarding compassionate family pension. Lordship.
648.
648 Lordship.
Hmm.
It's 684 Lordship. 684. That has already been. They all earlier occasion I have supplied that one.
Yeah,
That has been supplied.
That is we have from.
That is there. That is. And para 13 is. Regarding Lordship, if we go by the merit of the case, Lordship, then Lordship several judgment is there also regarding unfair exception. Lordship. No, not on merit, only on compassionate. That's why it is called allowance, compassionate.
Okay,
Mm.
then anything else? Just now you have said that discipline one.
Discipline, Lordship, discipline part. When Lordship, the unfair exception, so many judgment is there, Lordship, right from the Dattalinga onwards, Lordship.
We are not on that.
Lordship.
It is not fixed that it is not that the petitioner.
Lordship. Because Lordship, the husband of the petitioner is no more. So Lordship, today, I.
Okay, we'll make a photocopy and give it to you.
Lordship, I have.
You have.
Even Lordship, in 2022, one SCC 370. That was also there, Lordship, regarding we can impose the punishment, Lordship.
2022.
Lordship, I have supplied the copy, Lordship.
373.
Lordship. Paragraph 15, 17, 18, 19, 20, and 30, Lordship.
15, 16, 17 and
15, 17, 18, 19, 20 and 30 Lordship.
15, 17, 18, 19,
19, 20 and 30 Lordship.
20 and 30.
30 Lordship.
Okay.
Regarding unauthorized absence Lordship, Mithilesh Singh judgment is there Lordship. That was also Lordship.
There are only many.
Unauthorized absence Lordship. Otherwise, Lordship, on compassionate ground, Mylon, that Mylon may refer the matter to the authority, they will consider Lordship. Compassionate part Lordship, without going to the merit of the case Lordship.
On 18th,
Lordship,
18th we have a working day.
Lordship,
Yes.
Though it's a Saturday.
Lordship,
We'll have
Lordship,
it on 18th.
Lordship, Lordship.
Third Mr. has not counsel a petition by the petitioner. And Mr. K. Gugul. Planet CGC 40 days. Place this matter on 18, 11, 30. Or necessary.
Lordship, Lordship.